Okay, yeah, hi everyone. Thanks for coming to this webinar. This is a very interesting topic. I think there's a lot of opportunities for lawyers in the middle of this crisis that we're facing. Everyone has a lot of uncertainty, a lot of new questions that are coming up about individual rights and what sort of rights do we have versus the government in the middle of this pandemic, and especially as it relates to criminal defendants. And are there any aspects of the criminal law and policies that can be changed in light of this pandemic, and also lessons we can learn about going forward, how we can reform the criminal system. There's also a lot of interesting issues that have come up about just the procedure of the courts, how they operate. I think people are realizing that the previous court procedures were inefficient in certain ways, and that there's better ways of doing things, and we're learning how to better do video conferencing, that types of things, filing documents online, and all of that. But Allison and I have been working together for about the past 10 years. We've done a lot of criminal defense in both state and federal courts, and we've also done a lot of work advising new businesses setting up in the middle of this pandemic, and how to advise small businesses how to navigate these waters. Allison, do you want to give a little bit of an introduction, background of yourself?
Yes, hi, nice to see everybody here. Just to start to tell you guys some funny things, and then we'll get into some substantive stuff in just a moment. But, you know, as you guys all know, working virtually and by telephone, funny things happen. And this week, the United States Supreme Court started doing telephonic oral live hearings. And during that experience, all the people listening could hear the toilet flushing from one of the Supreme Court members. And of course, there's been a bunch of different hacking on Zoom. So that, of course, is an issue for confidentiality, which we're going to get into further today. But we're happy to see everyone, and we're happy to go over everything today. And what we're going to be going over, as Raza indicated, is first what the state court rules are, some federal court rules. And then we're going to be going over the case law trends on COVID-19 relief. And if you can believe it, there's already been about 87 cases that have come down from the state and federal courts in the Ninth Circuit and in our California state courts, just on COVID relief, emergency bail motions, exhaustion of remedies, and these kinds of issues. So Raza is going to start us off with the court rules and kind of like an understanding of where we are right now. And in terms of lawyers, just to start with this, are we essential, are we not? Under the governor's ruling, it says the lawyers are essential if they're dealing with essential services or they're dealing with necessary court issues. So I guess for criminal defense lawyers, we would be, I believe, considered essential. But that being said, there's still recommendations, obviously, on how to work and to work virtually if one can. So with that, Raza will launch into the substantive portion of our conference today, and we're going to start with just where we are right now in the stay-at-home orders, and then we're getting to criminal law rules and then criminal law trends.
So just in terms of where we are as a state, things have been moving in the last couple of weeks. Everyone pretty much was on lockdown starting in the middle of March, and there have been some recent developments just this week that have maybe raised more questions than answers, but have gotten a lot of people thinking and talking about how we move forward. I know in LA County, I know everyone's not here is not from LA, and that's one of the interesting things now is we're seeing different counties going forward at different paces in terms of opening up. But in LA County, the county announced earlier this week that our lockdown would basically be in place until at least August, at least 3 more months. I think that was kind of discouraging to a lot of people, but it's kind of sinking in that we're going to be in this for a while. The mayor, Garcetti of LA, announced earlier this week that there would basically be some lockdown in place until we essentially have a cure for the coronavirus, which no one knows how long that'll be, if ever. We also had in LA a new order coming out last night that everyone is expected to wear a mask when they step out of their home, even when they're outdoors. Everyone who's 2 years old or above needs to wear a mask walking around. So we're all kind of adapting to these new procedures, but we're also seeing signs of other parts of the state that are opening up faster. Especially rural areas, we're seeing opening up at a faster pace. Yesterday, California officials announced that 16 of California's 58 counties are allowed to more fully reopen, mostly rural. Now, we have these different stages that we're working through as a state and different counties. Right now we're in the middle of stage 2. We went into that about a week or two ago. And basically we're allowed to have certain retail businesses start opening up now. We're seeing just with curbside pickup and also manufacturing and logistic chains, we're seeing opening up more industrial jobs. We're not seeing people allowed to shop inside retail stores yet, but some counties are starting to move through at a quicker pace. Just as a summary of the state policy, basically the state's looking at counties to see if they meet certain benchmarks in order to move forward. One of those is that have been no COVID deaths in the county in the past 14 days. That's a pretty stringent one. Some people think it might be especially strict, but there's certain benchmarks like that, minimum daily testing volume, testing availability, and so forth, that counties have to show that they're meeting in order to move forward through this process. Now, the good thing is that hospitalization in the state, it hasn't really spiked up. It's been fairly flat, which is good. That's what we've been trying to do, is flatten the curve. It's been working so far. We've been keeping the numbers down. But we're working through these stages where a lot of people think we're going to be in stage 2 for a while. Stage 3 is more large gatherings, concerts, sports events, that type of things. A lot of people don't think we'll be there for a little while. And then stage 4 is the end of the program. But these are stage 2, the ones that are starting to open up: retail, manufacturing, offices, more public spaces. So we're working through these different stages, basically. Now, in terms of the court system, we've seen different orders coming down from the state and from the city of LA. This is just a release that came out yesterday from LA extending the court closures through June 10th. Right now, there's just certain emergency proceedings that are going on. And every county is doing things a little bit different, but we have these state orders that I'm going to get into that have been basically allowing the counties to do this reform that we're seeing. Now, the courts have still been operating throughout this crisis. They haven't shut down. We don't have martial law. We still have courts operating, and they're still doing what are considered essential or emergency services. But the reality is the courthouses are some of the places that are most prone to spreading the coronavirus. They're indoors. They have people packed inside. You have people coming from all over the place, all corners of society. You have parties to the cases. You have witnesses, judges, court employees, jurors. And while there, you see people packed together in elevators, waiting rooms, security lines, and courtrooms. And then during a trial, you have jurors who are hanging out with each other, sitting next to each other while they're hearing the evidence and deliberating. And then during all this, you're having inmates going back and forth on buses. So it's kind of a sort of breeding ground for coronavirus, and we're having to sort of rethink how the court system can operate in this new reality that we're faced with. We've been appearing in various courts around California over telephone and Zoom these past few weeks. Typically, for the most part, we've been continuing cases for several weeks when we've been appearing, but not everything can be put off, not everything can be continued, and some things are urgent that the court system needs to deal with, whether it's because someone poses a threat to the public and needs to be locked up, or has a right to exercise their trial rights, speedy trial rights, so they're not sitting there forever, or for defendants who are sitting there in custody who are exposed to the virus, especially if they have certain health conditions. There's an urgency to having a hearing and helping to get them out of there. But also we're seeing, as we make these reforms, we're seeing about lessons that we can learn about how courts are maybe inefficient in certain areas. Sometimes they're inefficient for a good reason in order to protect important rights, but sometimes we just have old habits in the court system that we've been used to doing things in a certain way, personally appearing on everything, filing physical manual documents in person at the courthouse, sometimes requiring an original signature required. And we're finding ways to do things more efficiently, teleconferences, filing documents electronically. and for lawyers, so lawyers don't have to be driving all around to courthouses back and forth all the time, how lawyers can appear telephonically or over video conference for sort of routine scheduling conferences at least. Now, when we have court proceedings that have witnesses, it gets a little trickier to do them over Zoom. We have, you have to judge people's demeanor. Sometimes there's certain nuances that come out in person that are not apparent over Zoom. And especially when you're talking about jury trials, we have a constitutional right to confront our witnesses in court, and a Zoom jury trial, a lot of people don't think would comply with the Constitution. So,
Rob, can you show us in the court rules here, like if you keep going down on that, what applies to criminal and what can be done through Zoom and what's supposed to be done in person?
Yeah. So
right here. No, right here, and also stop right there about the criminal jury trials and all this this part. Thank you.
Yeah, so what we're seeing right now in LA, and this is similar to other counties around the state, is that they've been sort of pushing off everything they can farther out into the future. And currently, this is the latest order. They just pushed off all criminal jury trials again until June 10th. There was a previous order that had pushed everything off until May 12th, except for these emergency proceedings. But at some point, if the jury criminal trials can't just get pushed off indefinitely into the future, or people are going to have start to have, speedy trial claims that you cannot just detain someone forever waiting for trial. People are going to have to start to be released. And we're going to get into the different procedures at the state and federal level that have been going on for inmate releases. But so far, all of these categories that you see up here have been generally put over: criminal jury trials, civil jury trials, unlawful detainer cases, which are a big thing, so people don't get evicted in the middle of the emergency. A lot of family law cases, traffic trials, infractions, and then most juvenile delinquency proceedings. Now, when you get at the state level, there's certain emergency orders that were put into effect that apply to the whole state that are changing the way we're operating. Just going to go over a few of the rules that are most relevant to the criminal cases. As I mentioned, there's unlawful detainers. Those are getting put off for several weeks. Nothing's really happening on that. No one's getting evicted. We have this emergency rule 3. This relates to remote appearances, allowing people to appear by phone, by video in criminal cases. The defendant can waive their appearances in a lot of cases where they couldn't before, and the lawyers are able to take care of things by phones and by video, and every court's sort of figuring out for themselves how this works. We're seeing new procedures in place, but courts are becoming more flexible in general to make appearances. Now, this is one of the more interesting ones, is the bail schedule, the emergency bail schedule that came into place. Basically, the new bail schedule statewide is that it's 0 bail, according to the schedule, for most offenses. There's certain exceptions that are put in place for strikes. That's not 0 bail. Those are serious or violent crimes. Certain violations of protective orders, witness intimidation, sex crimes that are registrable on the sex offender register, certain domestic violence cases, violation of restraining order, criminal threats, stalking, and also felony looting, which is defined as burglary or grand theft during a state of emergency, which we're in. So there are certain offenses that will cause people to be held in jail still, but most of the criminal offenses, most all of which had high bail in a lot of cases, that the bail's gone down to 0. It's been a real interesting social experiment to see how that works out. And
that being said, and we're going to go over this in a little bit, despite the fact that the statutes look really promising, they haven't been interpreted as promising as we would like. So we're going to go over some of the case law that's emerged, but it seems that the courts have determined so far, at least with respect to this case, Iowa versus Superior Court from the 4th District. We can get to the citation for that. They were considering San Diego's new post-COVID-19 bail schedule and indicated that it was allowable even though it didn't reflect the bail schedule as set by the Judicial Council. And another thing interesting about this case is that it leaves open whether or not the court believes that the Judicial Council can even have the authority to do this bail schedule. And that's explicitly mentioned in this case. So this is right now the leading case on this. Hopefully hopefully there won't be more cases because people won't need that. But there's already been 87 cases that have come down, as I started with, regarding either California's emergency bail or the federal one. But this case, unfortunately, kind of undermines what the Judicial Council is trying to do with respect to the whole bail system.
Yeah, a lot of people had thought that the Judicial Council was basically ordering all the bails set at zero, but based on this case that's come out, Ayala versus Superior Court, zero is the presumptive bail. It's the scheduled bail. So it's just like the old bail schedule where judges can still set bail above zero for these lower level offenses if it's justified based on the usual standards of bail. So, judges still have the ability to jack up people's bail and put them into custody for these offenses. But we're seeing a lot of people being released under this schedule, and counties are having a lot of flexibility. Individual counties have ability to lower bail beyond what this state schedule is, and we're also seeing that for all probation violations, the bail is also at zero, where they used to be able to hold people indefinitely in some cases for felony probation violations. Now the bail schedule is going down to zero, unless it's for one of these exceptions for the serious cases, like the strike cases or the stalking, where people are actually very dangerous. Now, this new bail schedule, it remains into effect until 90 days after the declared emergency is over. It'll be interesting to see what happens with bail after that, whether it just jumps back to the old system or whether this will have permanent effects. A lot of people predicted that when these new zero bail went into effect, we'd see a real spike in crime because of prisoners being released, people coming out of the county jails back into the neighborhoods. I think the jury's still out on that one. We're looking at the data. But the hope is, at least my hope is that we're going to see that we used to be locking up a lot of nonviolent people who are not really dangerous to the community, who really should be out of custody at least pre-trial while they're fighting the case based on the presumption of innocence. Whereas before, under the old system, it was too easy for the prosecutors to just get people locked up and pressure them into pleading guilty to crimes they might not have even committed just so they can get out of custody. But we're seeing now what a more liberal bail system is like, and whether this will endure in the future. Now we did see some prosecutors playing some games with this before. We saw at one point the LA District Attorney's Office was trying to get around the no bail rules by seeking arrest warrants for certain amounts and then arresting people. We saw that in San Bernardino and Orange County, the sheriffs were highly critical of the new zero bail law when it came out. But now we're seeing how that pans out.
Now, that being said, I think it's interesting just to kind of, maybe we can talk about this and people in the audience can share with us how this is being interpreted county by county. I know in LA, where we have obviously the highest number of COVID infections, the police haven't really been putting people in jail for the offenses that are listed. And maybe that's because they're trying to respect the Judicial Council. I think it's mostly because they're afraid of getting COVID. So I think where you see, really high rates of infection, the police don't want to arrest people and are happy to kind of have an excuse not to, so they don't expose themselves. Because it's interesting, the other day I was just looking, my daughter's a big Billie Eilish fan, and I saw that she had a stalker who had come to her house. And there was this statement by the police, or that they couldn't really keep him in custody because this was a zero jail offense, when interestingly, actually stalking is not zero bail. So I just think that, and then also I've heard of other commercial burglaries where people aren't getting arrested. So, and I'm not critical of that. I think that the police are, considering the level of threat to themselves and even arresting people, and that the, prevalence of and how the infection spread throughout the county kind of is determining the way that the county is reacting to the bail situation, which is pretty obvious. But that it does seem to be a pretty big consideration. Now,
I'd mentioned these personal appearance waivers. That's kind of interesting. It used to be that defendants had to appear every time in court, at least on felonies. Now there's the new rule is that until 90 days after the emergency is over, all criminal court operations can be conducted remotely with the consent of defendants, whether they're in or out of custody. And that can be done by either phone or video conference, and by e-filing and e-serving documents. Now this rule applies to everyone, all criminal defendants in the state except for murder defendants with special circumstances or defendants in state prison. For everyone except for these groups, with the consent of the defendant, the lawyer can just appear on the defendant's behalf while we're under this emergency. Now there's also for juvenile court, for people who practice in that area, there's certain categories that are supposed to be given priority, and then most everything else is getting pushed over. But the juvenile courts are still working on prioritizing psychotropic medication applications, emergency medical requests, petitions for reentry of a non-minor dependent, hearings on a request for a warrant for children, and a probable cause hearing for defendants for child defendants who are detained but haven't had a detention hearing. And then we're also seeing in juvenile delinquency hearings, those are still proceeding under the statutory timeframes. The remote appearances are allowed in juvenile court if in-person appearances are not feasible. And the court still has to determine if it's contrary to the welfare of the child to remain in the home, whether reasonable services to prevent removal occurred, and whether to place temporary placement with the probation agency if the court will be keeping the child detained and out of the home. Other juvenile delinquency hearings for minors out of custody, they've generally been continued until after the declared emergency is over, other than the types of hearings that are given priority by the order. Now we're seeing, in terms of the courts opening up, the courts are still open for limited services, but they're going to be opening up on a broader scale after this sort of emergency period is over. In LA, like I said, it's going until through June 10th is the current plan. And what's going to happen in LA is the clerk's office is going to reopen on June 15th. And then starting June 22nd, you're going to be seeing them hold regular hearings on everything. But in the meantime, they're putting in place all of these new procedures that we're going to be seeing in courthouses all over the state. We already are in a lot of cases. But what we're seeing is these are the bullet points that kind of show the new processes in the courts. You're seeing face coverings by all judicial officers, and interesting to see judges up there on the bench wearing a mask. It's interesting as sometimes it can be hard to understand people when they're talking. It can be kind of muffled with the mask, but people are learning how to do it. We're seeing judges wearing masks, all employees, all court visitors wearing masks with only limited exceptions. You're having markings for social distancing so people can stand apart in security lines, that kind of thing. You're seeing right now you're seeing limitations on who can come into the court. It's just sort of authorized parties, attorneys, the media in certain situations, but they're trying to keep the general public out. The sheriff's deputies are supposed to be enforcing social distancing requirements in the courts. We're seeing hand sanitizers and wipes everywhere at the entrances, inside courtrooms, and other high traffic areas. And they're doing sort of deep cleanings of the courts a couple times a day in the high traffic areas, like courtrooms, a clerk's office, restrooms, handrails, door handles, knobs. And these are the same kinds of processes that they're doing in businesses that are reopening and offices all over the state in order to keep people from being exposed to the virus.
Now that being said, I would not want to go to court myself for, quite a long time. And I think one of the things that's going to be kind of an ethical and, professional considerations we're going to have to figure out is if this keeps going on, for who knows how long, can we decide to do virtual, preliminary hearings instead of obviously someone having to wait till some unknown time to do their hearings? Can we even maybe do jury trials this way as opposed to someone what if someone's in custody and isn't able to get out on a bail motion? So those are the kinds of, I think, considerations we have to think about. And also something I've been thinking about is how are we going to how are we going to make the same kind of dramatic flair and kind of the presentation that we make in court and also have the intensity that we like to have when we cross-examine witnesses, and are we willing to give that up, you know, in order to continue to obviously just make things go along in a case. And obviously in each case, it's a case-by-case consideration. Whether the person's in custody is a huge consideration, but these are the kinds of strange things that we're gonna have to be thinking about now. Raza, should I move on to the case law? Are you done with that portion?
Yeah, should we get into the federal?
Yeah.
The federal law?
So
let me just pull up. I have, sorry, go ahead.
Yeah, so if anybody has, of course, any questions along the way, we're happy to answer. The kind of summary of the state court situation is that we're doing a lot of appearances through Zoom. You would think that you could get a bunch of people out of custody. It seems to obviously depend on the county and, you know, the rate of infection in that county and the kind of attitude of the county towards the coronavirus, like in general, I think dictates a lot of, you know, whether or not these motions will be well received. In our county, for example, it seems like they're not arresting people even when they can. Then, you know, we just talked about obviously ethical considerations and professional considerations that we need to make now in these times. And now we're going to move on to the federal court. And Raza's going to discuss it for a few minutes, then I'm going to launch into it. This is the memorandum from William Barr saying that a home confinement needs to be prioritized for nonviolent offenders, especially in the federal courts. So that was very exciting when that came out, and kind of and obviously a silver lining in this entire tragedy. But unfortunately, when I spent the last week going through all the cases that have come down in this area, it seems that very few people are actually getting out. And what I went through when I evaluated this was the state and federal cases, California Ninth Circuit. And it seems that even where people have cancer and other illnesses, they don't always get out of custody. And one thing that we're going to talk about today is that most courts think that you have to exhaust your remedies first, which means going through the Bureau of Prisons first, and then if you're unsuccessful, going to the court, which is at least a 30-day process. So that's something that we're going to be discussing. I have a question here. It says, are clients able to access technology to participate in virtual hearings? Will something be provided for clients who do not have smartphones, et cetera? So, Raza, you've done a couple of our court appearances on Zoom. Can you talk about that for a moment?
Yeah, so far I've been appearing without the clients on the court cases. I think there would be
even for felonies, right? You've been getting 977.
Yeah, even for felonies under the new rules, the defendant only needs to appear in person for murder cases or if they're in state prison, but otherwise they can waive their appearance. Now they still have a right to appear. And
by the way, you don't have to do, just to be clear, you didn't have to fill out a 977B waiver, which normally you
That's correct. Yeah, it's automatic under the emergency rules.
And one of the things though, how about, we haven't had this yet, but maybe someone else in the audience can talk about it. How about someone in custody? I don't think that how are they handling something in custody when let's say you're out, obviously is there a way for a lawyer to appear virtually while someone is in custody, or would the lawyer have to be there? That's one thing.
I've seen videos of preliminary hearings that are done, where the people are in custody in jail, and they still show up on video conference. You can see them in their mask from inside the jail doing the Zoom call. And then
what about this issue? And Raza, what about this issue? And everybody else knows. How about how can the client communicate with the lawyer though if the lawyer isn't there and they're on Zoom? Is there a setting for that?
Yeah, I think people are learning how to do that. There's ways you can break out on a Zoom call to do private calls. I think it's like with the toilet flush at the Supreme Court, everyone's still kind of learning, and you have to be careful that you're not having a private discussion. A defendant where other people can hear. But
that's another issue too, because, and this is something, Raza, maybe you can pull this up. This is another issue that we're dealing with, which is our, duty of confidentiality. And is it even, let's say you are on a private, let's say that there's a way for you to do a private, conference with your client on Zoom. Is that even going to be considered, is that even confidential when, Zoom is routinely hacked? I just read an article today, I think I sent it to you this morning, Raza, that's in Law 360 today. And it's about how a prayer session was hacked by some people doing showing pornography on Zoom. So that being said, that's kind of I think that's a little bit funny, but it wouldn't be funny to have a police department or anybody being interfering in your Zoom call with your client. So this is something that I think is going to need to be obviously addressed. Raza, do you know how the clients and lawyers are doing it in those scenarios right now?
I think they're just trying to find the most secure way to do it as possible. And yeah, we've seen that Zoom is capable of hacking. I think there's ways to, maybe those people didn't have passwords and that people got the Zoom number, or people somehow got access to the Zoom number and passwords. But I guess be careful about who you share your passwords to. If you put them in a public place, like on the internet where everyone can see them, that's, I think, where people are getting bombarded with the visitors coming in. But, you know, don't share your password around widely. But it definitely raises a big concern now that so much is being done over Zoom and video conference, that there's either random hackers coming in to create problem, or that government officials could be basically doing surveillance, you know, mass surveillance on people, listening in on calls of people who are there suspicious.
I think the best way maybe for now, what I would say is that if the person can almost make, like, because they're going to be in their holdings in a place anyway, that they would be able to step out and make a telephone call, a collect telephone call to you. So that's going to be hard as a lawyer to set up, but I think that kind of needs to be the setup. So what I would suggest, what I think, and I mean, we'd have to make this happen, is that the client be able to access a phone during the hearing, that you would have your phone connected. And this is something all lawyers, I'm sure most of you guys have done this, but in case you haven't, you have to set up your phone to be able to receive, collect calls, your cell phone or your regular phone, usually through Global Tel-Link. And then you have to have I think the client be able to actually just call you during the hearing on a landline, or call from their landline to your cell phone, and then you can do that confidentially and go back to the hearing. I kind of think, even though that sounds kind of cumbersome, that for the moment, that would be the one way for a lawyer to not have to be in court, but to actually do the best to preserve the duty of confidentiality. So moving on from that. Roz, are you showing this document still?
Yeah, so maybe let's just discuss this, the federal prison release. We talked about the release of pretrial inmates at the state level in California, and the zero bail. At the federal level, there's a procedure for the release of inmates that's come down from Bob Barr, the Attorney General, and it's basically giving a lot of discretion to individual prisons to release people. The Attorney General discussed that there are some at-risk inmates who are nonviolent and pose minimal likelihood of recidivism, and who might be safer serving their sentences in home confinement rather than BOP facilities. And especially federal prisoners, there's a lot of nonviolent federal crimes, especially drug crimes, that have really harsh prison sentences, but the people sitting in prison they're not violent people. They don't really pose a threat to anybody. And it's great that we're seeing these people be able to get out of custody as much as they can. What prompted this federal memo is we started seeing a lot of deaths inside of prisons and people catching coronavirus. It kind of goes like wildfire through the prison once it pops up there, because people are so confined and there's no way to really get out away from it. It's kind of like the courts; they're sort of ideal breeding grounds for coronavirus. So once we started seeing,
right now, like, there was one of the questions from our audience member was, this was anonymous attendee asked the following: there's evidence inmates intentionally making themselves sick with COVID by removing their masks and coughing into each other's faces. So why should they be released if they're now sick? Well, my argument, I mean, this isn't obviously an argument today, but I would say that the issue is that keeping people in the jail sick, it also poses a threat to other inmates as well as to the staff. And I think a lot of people, when you read about the outbreak in New York, a lot of the reason it became what it did was because in New York, they had prisoners burying the COVID victims in this big, basically grave in Hart Island, and they were doing so without protective gear. Then all of the officers and law enforcement ended up getting sick, and that, ended up getting like this. Of course, New York is one of the hardest hit places. So it's not just a matter of the people that are, what they're doing, but it's the effect on obviously others.
So the federal memo, it gives out certain guidelines to look at in order to release people, the discretionary factors. They look at the age of the inmate, whether they have pre-existing health conditions. There's a list of conditions that make people higher risk for COVID-19, as well as if people are over 65, that the odds of bad health results are a lot higher. So they look at that. They look at the security level of the institution. They give priority to inmates who are in low level and minimum security facilities. And then they look at the inmates' conduct in prison. If they've been committing violent conduct inside the prison, assaulting other prisoners, or have other BOP violations, they don't get priority treatment because they're considered to be a bigger threat to society, basically, if they get released.
Now in reality, having gone through a bunch of these cases over the last week, and I kind of glanced at all 80, but I looked deeply at about 30 of the cases that have come down. And then, of course, we've been watching the news. And unfortunately, it seems like it's been a very kind of political, it's been somewhat political in terms of who's released. Yeah, there's about 5 cases, and we can show that to you, Raza. We have a, on our website, you can go to like a showing of all the cases where people have gotten out. And there have been, obviously judges who have made those kinds of decisions, even where people weren't connected politically. But it does seem that, there's obviously political considerations, and some high profile people were getting out very quickly, such as Michael Avenatti and Manafort. And not to say that we don't believe they should get out. It's our opinion, at least my opinion, that there should be probably the majority of prisoners should be released in the federal system due to COVID, and that there's a way to probably release everybody in a safe way to prevent this. But there does seem to be, obviously, as there usually is, a political element to this. And, there are people who are high risk who aren't getting out. And I think that it would be nice, and obviously helpful if, given the fact that there may be less people in custody, we can start to use some of the, prison guards in a way that we didn't think about before. Like, for example, let's say there's a high risk inmate, but it's best for him to leave for public safety, so that people don't get COVID. Then why not, put a police officer or a prison guard in front of that person's house, and obviously put them on electronic monitoring, et cetera. But I think it's the time that we can come up with creative solutions to be able to really prevent the spread of this. But it's going to require, obviously, the work of many parts of the community, the criminal defense, as well as obviously law enforcement community coming together to figure it out. But at the moment, there aren't really many people who are actually getting released. And Raza, do you want to also show us, when we get to the next picture, some of the factors that are considered, in getting out, and also some of the case law?
Yeah, well,
kind of analyzed it too.
Yeah, these are the sort of main factors under the original federal policy that they look at. We've gone over some of them, but one of them is also whether they have a plan to go back into society, that they have a safe place to stay where they're not going to be just like out on the streets, spreading it around on other people.
By the way, with that, I just want to say with that factor, when I was and Raza, maybe you can pull this up. And I'm not criticizing the decision. I'm just saying, I don't think this would be considered for most people. But when we were looking at the Michael Avenatti today, he was going to stay on his friend's couch in Venice. And that was going to be where he spent his 90 days of out of custody time. So, I just think that there's many people who could stay on people's couches, and that was considered to be acceptable. Raza, maybe you can pull up that Michael Avenatti order also.
Yeah. Let's get into that. There's a follow-up memo though to the March 26th one that on April 3rd, they came up with a change in the policy based on they were experiencing significant levels of infection at certain prisons. I know that the federal prison in San Pedro, just south of LA, was having a lot of spikes and big outbreaks. But they loosened the federal policy a little bit. Basically, under this new memo, under this new April 3rd, any and all vulnerable federal inmates are eligible for transfer to home confinement. There's no one who's considered ineligible. And the Bureau of Prison Wardens, on an institution-by-institution basis, get to decide, based on the same considerations. They look at public safety risk, and they don't have the same age or offense-related restrictions as they did before. So it's worth trying for anyone who's a federal prisoner. We've helped write various letters to prison wardens, trying to get people released based on these factors, laying out the circumstances, and it's definitely worth trying, because I think a lot of people are sympathetic these days about people's predicaments, and if you just try, good things can happen. So based on these policies that are loosening up for releasing inmates, I would say for everyone who knows anyone in custody, it's worth taking a serious look at, because based on these discretionary factors, you can possibly make these things happen for a wide variety of people. So this is, Michael Avenatti. It's interesting. People were just talking about him possibly running for president just several months back. He was kind of a national hero, but then he ended up in federal prison. And he has, this is an order allowing him to get out. And
can you show me, Ross, can you stop there? Those, just so we can see the conditions here. These are kind of, the way the conditions look on this kind of thing. And you can see them there. Where's the part about him going to stay in Venice? Unless I'm, oh yeah, let's see here. Oh yeah, here we go. Oh yeah, here we go. Guys, look at this. Number 8. I'm just saying, defendant shall be released to the custody of third-party custodian Jay Mannheimer. And he's going to be like, I think and it definitely said in here that he was, here we go. And then look at number 9. Upon defense release from Metropolitan Correction, New York, he shall be transported to the residence of the third-party custodian in Venice. Now, like I said, I have no problem with this, but I just think this should be, and of course this isn't precedent, it's just a decision, but maybe with persuasive authority if any other person wants to stay on their friend's couch in Venice. So I just thought that was kind of an interesting and relevant factor.
Allison, did you want to discuss a little bit the immigration center issues? That there's also people being held in immigration custody, and we're seeing policies about that. Did you want to get into this case a little bit?
So this is a case, Ross, can you go down a little bit? Okay, so this is stop there. Okay, so this is a case that was filed by ICE detainees and Mesa Verde Detention Center. It was a proposed class action saying that they're at serious risk of becoming infected by COVID. And the court agreed that they could provisionally certify a class. And they also filed a motion for a temporary restraining order requiring ICE to take measures that will enable social distancing. Raza, can you move down a little bit so we can see this? And the court here agreed that Northern District Court was a proper forum for the action. This is right here. The court, let's see, in roughly 14 days, they're going to hold a preliminary injunction hearing to determine what measure, if any, ICE must take to ensure social distancing. So in terms of whether or not the Bureau of Prisons has to adopt procedures to make the chance of people contracting COVID less, the courts are aggressive on that issue. But in terms of whether or not that means that you need to be released, the courts, many of them, seem to suggest, and then Raza, if you can maybe show this in another case, that first you have to exhaust your remedies with the Bureau of Prisons. But this case, instead of release, it involves making the Bureau of Prisons take action to decrease the likelihood of people getting COVID. Oh, can we let's discuss also United States versus Holden, because this is a case that talks quite a bit about what we kind of just started talking about, the exhaustion of remedies. So in some of these cases, the defendants were going and filing straight in the district court and saying that this was not a time where they needed to follow the usual rule that requires exhaustion of remedies first with the Bureau of Prisons. And the courts have been somewhat split on it, but many of them have determined that you do have to go through the Bureau of Prisons first. That being said, these are all issues of first impression, and I, of course, encourage everyone to try to do, to obviously go through the Bureau of Prisons, but if they think there's not time, to try to apply this way. And the way that you go in federal court to be challenging bail conditions based on COVID-19 is through the FSA, the First Step Act, and this does require exhaustion of remedies. And what's interesting is it depends on what act you're using in order to try to get released, in order to determine what that act requires regarding exhaustion of remedies. So there's the Compassionate Release Act, and there's also the FSA. And so you have to look at the act that you're applying under in order to determine whether or not you have to exhaust your remedies. But generally, the courts have determined that you do have to go to the Bureau of Prisons first. And this is just an overview of the First Step Act.
And this was actually a pre-coronavirus criminal justice reform that allowed people to get certain credits and be released early if they were not considered a threat to society.
Okay, this case, wait, can you go back to the top, please, Ross, for just a sec? So this is U.S. versus Casares, April 23rd case that just came down. Ross, can you go down so I can just explain a little bit of this? So this is the actual case in which the magistrate court, felt that the person should be released, and that and then the district court ended up overruling the magistrate court. And this defendant happened to be someone who was convicted of a violent offense. But that being said, the magistrate court still found that it would be appropriate, given certain measures, to release that individual, and the district court said no. And it was a very serious case, but it's interesting that with something like this, you would think that the district court would go with the magistrate's opinion and err on the side of release in this type of time. But you can see that here they actually
they balance the factors, and they find out that because it's a serious violent crime he's charged with, he's caught up in gang-related activity and so on, that he's not a good candidate for release.
And this was a case just from April 10th. Raza, if you can just get down a little bit there. So this is a case involving, this is United States versus Mayhan. Oh, this is a case this is actually a good case. That's why I showed it to you, even though it's from the District of Idaho. Is that in our circuit, Raza?
Yeah, I believe.
Okay. So this is still in our circuit, actually, Idaho. And this is actually a good case where a defendant is released, who's a nonviolent drug offender. And so I wanted to include this because this is one of the few cases where I found someone was released. And there was only about 5 to 6 cases like that where someone was released.
This is the case. It was a drug case, like there are in a lot of federal cases, where this guy had a mandatory minimum of 10 years to life, but it was for conspiracy to distribute methamphetamine, non-violent crimes. So there's a lot of federal prisoners who are subject to these mandatory minimums or harsh sentencing guidelines who are really not threats. But this is an example of a case where someone who had a big sentence had some success with the courts.
And Raza, can you go back and just see, did he raise this under the FSA, or what statute did he raise this under? Let's just see here. Because this, like I said, it's important to look.
He was it says he did not specify the basis of his request.
Okay.
So
you can see here, so if a judge wants to let people out, they let the person out. You can see here, this guy doesn't even specify the basis for his request. Other times, you don't go to the Bureau of Prisons, you're basically like, in a place where the whole place is infected, and you're a vulnerable person, and the judge says that you have to go through all these, hoops. So it's really obviously court dependent. And this is also available on our website, and this is just me showing you that many courts in the circuit have decided there's no reason apart from the exhaustion requirements. So if the court wants to, they do, and they can just release you. And if the court wants to not release you, they can come up with ways to not release you. And the biggest way that they come up with is this 30-day exhaustion requirement that's present in this 3852.
And here's a related issue that's come up. Sex offenders generally have to go appear in person for registration updates, and there was a lawsuit saying it was cruel and unusual punishment to require them to go appear in person to register as a sex offender and do that. So that's being challenged, and also similar challenges to probationers who have to go check in every month. There have been various challenges over whether that's required, and hopefully they'll be having more use of technology for remote check-ins for sex offenders, probationers, et cetera. So so you're not unnecessarily exposing them and the government workers.
Raza, what was the result of this? I think that the preliminary in Fresno, I think that the court preliminary said that they don't have to appear. Is that right? Let's see here. Oh, it says that there hasn't been Eastern jurisdiction. Okay, so it looks like that hasn't been resolved.
As of May 3rd, this was not resolved, but it was filed as complaint.
Okay, I thought I saw something on Lexis that looked like the resolution of this. And here, Raza showed them these, and then Raza showed them these Michael Cohen and Michael Avenatti articles. So this is interesting. Michael Cohen, here's another, so this went a different way, of course. He had been notified that he was going to be released to home confinement, and then that was rescinded. So like we kind of said in the beginning of this has been a very, in some, where you have a just jurist, then it's not a politicized event, but this can become very politicized. And then here's an article about Michael Avenatti and his release. So just in terms of resources, Raza, can you pull up the NACDL website? Basically, there's obviously motions available all over the place, but one great place to look, I'm sure everyone here knows, is the NACDL website. They have, you can find motions here. And another thing that
coronavirus resources, where they have sample, they have all the government orders and memos, but they also have sample motions that you can file to get people released. There's a lot of good ones, templates to challenge pretrial confinement, letters to the wardens, et cetera. So there's a lot of really good stuff on that website for resources.
And I think, like, for the last couple of minutes, there's one more area that COVID-19,
One thing also just I wanted to get into just briefly, it's kind of interesting, is there's been different enforcement levels of the social distancing rules. In some cases, they've actually been arresting people for social distancing violations, which seems a little bit strange because you're then exposing them to a lot of extra people for doing so. But in New York, there was an article recently about how they arrested 40 people for social distancing violations over a weekend, and 39 out of those 40 people were non-white. So I think you're seeing that to the extent they're enforcing these rules on the streets, it's kind of like the war on drugs. You're seeing it hits hardest on minority and lower class communities, and there's real concern that a lot of these rules and the enforcement are going to hit poor people and minorities the hardest, while more well-off people can kind of sit inside their big houses and be okay and ride it out. So that's the other part where we're seeing is the enforcement of the smaller rules at the criminal level, and how that might have a certain bias to it and unfair to the most vulnerable people in society.
That's obviously that's a huge issue that we're going to be dealing with through this. And I guess the last issue, just to touch upon for the last 3 minutes, Raza, can you pull up just like something about the PPP and False Claim Act? So just kind of to deviate a little bit, but there might be some new, criminal cases coming about, hopefully not. But there's all these federal loans that are not now available from the government, such as the Payroll Protection Plan, the EIDL loan, and all these require individuals or businesses to also have keep records of how they're spending the money. And there may be litigation that comes from this under the False Claims Act. So that's something just to kind of on a kind of the, I want to say, white collar criminal front, to be cognizant of kind of things that might happen in the future relating to some of the COVID-19 stimulus packages. So I guess if anybody has any questions that they haven't answered, feel free to reach out to Raza or myself. Our website has all those cases on it. We're happy to talk to you guys. We're obviously here at home and sitting in front of our computers all day, and we love to talk about the law. And we really appreciate being able to be here today on the CEB. Of course, I'm sure like everyone out there, the CEB has been our Bible since before I started practicing law. When I was at Berkeley we had a Harvard-Berkeley exchange program. This is like 18 years ago. We had a class just on the CEB, and it was awesome, and we're still using it. And just to leave you with this is Raza's just pulling up here the Payroll Protection Program, loans and risks of government investigation, advice from former federal prosecutors. So,
and basically there was a very limited oversight for people applying for PPP, and some people think that there was potentially a lot of fraud that was going on, people who were not eligible claiming they were, and there may be some level of scrutiny on that going forward, and there might be some sort of white collar type of criminal cases going forward to people who are committing fraud or other improprieties relating to all that, because there's a huge amount of money that was going out the door basically to people all over the country under this program, and there's been a lot of complaints about people getting it who maybe weren't the people who it was intended for.